While we're waiting for them, let's go ahead and call the matter of the people state of Michigan versus Daniel Loew. Let's have the appearances, please.
Judy Casman on behalf of the people of the state of Michigan, Your Honor.
Your Honor, Kathy Springstead on behalf of the defendant, Daniel Loew, who is here with me to my right.
Mr. Loew, state your name, please.
Daniel Loew.
Very good. All right, please be seated. Ms. Casson.
Thank you, Your Honor. On July 16th, the Supreme Court did author a decision basically upholding the Court of Appeals denial, or basically sustaining the conviction, and also upholding the Court of Appeals and denying his motion for a new trial. And the Supreme Court decision does have immediate effect. This court issued a stay pending appeal, and all appeals have now been had. So the stay would end. So I would ask that the defendant be remanded to the Allegheny County Sheriff's Department to be sent to the Michigan Department of Correction to serve a sentence.
Counsel.
Thank you, Your Honor. The Supreme Court opinion was actually affirming the Court of Appeals decision reversing Your Honor's grant of a new trial. Court of Appeals order does not have immediate effect. In fact, there's a court rule MCR 7215F that says the Court of Appeals order does not take effect until the Supreme Court has made a decision if an appeal in the Supreme Court has been pursued. Obviously, we pursued that. Court rules also provide the defendant with the right to file a motion for rehearing in the Michigan Supreme Court. We have 21 days to do that. And according to court rule MCR 7.211F, I believe, it is not until that rehearing has been decided, either held or denied by the Supreme Court, that the order and opinion from the Supreme Court will get conveyed back down to the Court of Appeals, and its opinion can take effect then. So I would argue that this hearing is premature at this point. Mr. Loew still stands as not convicted of this crime. He is still in a pretrial posture until we have pursued all of our further appeals, which includes a motion for a rehearing in the Supreme Court, and also would include, according to People v. Jones, a Michigan Supreme Court case, also include our petition to the United States Supreme Court for certiorari.
Ms. Casson.
Your Honor, 7.315D does indicate that the Supreme Court decision takes effect immediately. She is correct. The Court of Appeals decision does not take effect immediately until 21 days. And they did file all their appeals. He's been out on bond for 3 years, approximately. And I think that there becomes a danger to the community at this point, because the Supreme Court did uphold the Court of Appeals decision.
To be fair, during that 3 years, there's been no incident whatsoever out there.
I'm not aware of any. However, the sentence in this case is a prison sentence. I don't believe that certiorari would be something that they couldn't pursue once he is incarcerated. And in fact, there's other relief he has to be incarcerated to seek. I think that the Supreme Court's decision should be honored, and that the defendant should be remanded to the Department of Corrections.
All right, Mr. Loew, you stand here convicted of a serious crime. In fact, I would characterize it as a heinous crime. And I don't know the facts or details of the crime that you've been accused of. For that is not what these proceedings post-conviction have been addressing. What these years of appellate review have been exploring has been whether you should be entitled to another trial or the possibility of an evidentiary hearing to decide if the actions of Judge Bakker and Prosecutor Koch deprived you of the right to a fair trial by an impartial, unbiased judge. I do not say, nor have I ever stated, that you are not guilty. That's not my place. But my concern centered on this: due to the extraordinary revelations of improper communication by Judge Bakker and Prosecutor Koch, you were in fact, or in appearance, deprived of the right to a fair trial. I maintain that every accused individual, from a former president of the United States to a local farmer, mailman, or grocery clerk, has the right to a trial presided over by a fair and unbiased judge. We in the Michigan One Court of Justice work hard to uphold that and all other judicial canons of ethics, as attorneys are to uphold the professional code of conduct. In this case, the actions of Judge Bakker and Prosecutor Koch were found by the Michigan Supreme Court to be unethical and lacking in integrity. The Supreme Court explicitly overruled and overturned the Court of Appeals opinion identifying the several ex parte communications between the two of them as administrative. And the Supreme Court explicitly stated these communications were an explicit breach of the judicial canon of ethics and by extension, the professional code of conduct for attorneys. However, the court went on to find that this breach did not constitute constitutional infringement upon your right to a trial by a fair and impartial judge. The conviction was therefore affirmed. This court and every court in Allegan County and in truth, the entire state of Michigan work hard to ensure each person that comes before the court is treated fairly and honorably. But to make no mistake about it, the behavior of Judge Bakker and Prosecutor Koch was found to be unethical by the Supreme Court. The actions of Judge Bakker and Prosecutor Koch have brought dishonor and shame to the courts of Allegan and perhaps to even the entire state. The damage done to public confidence is hard to measure, and the work to rebuild and maintain that confidence will no doubt be daunting, but that is what we swore to undertake when we took the oath to become a judge, as attorneys took the oath when they swore to enter into the bar. The Michigan Supreme Court indicated it would be appropriate to explore disciplinary measures apart from this proceeding and in the name of preserving public trust and confidence in the judiciary's ability to police itself and attorneys practicing within it. I hope that significant consequences are imposed. At this time, I have no choice but to revoke bond and remand you to the custody of the Department of Corrections pursuant to the sentence imposed upon you by Judge Bakker. I hope that the stain upon the Allegan County Judiciary is washed away by the integrity, honor, and respect warranted by other judges within this county, as well as the state of Michigan. We do our utmost to work to redeem, and we will do our most to work to redeem and restore that trust damaged by the actions of these two individuals. You are hereby, sir, remanded to the custody of the Allegan County Sheriff's Department for further proceedings. Anything further?
No, no, Your Honor, thank you.
Yes, Your Honor, I'd like to make an oral motion for resentencing. I'll be filing a written motion to that effect, asking for Mr. Loew to be resentenced because his prior sentencing by Judge Bakker was not the product of an unbiased court. He has a due process right under the Constitution to be sentenced by an unbiased judge. I'd also ask or lodge for the record my objection to his remand today. I don't believe that MCR 7.215 F2 has been satisfied.
Your objection is absolutely noted for the record and preserved. In regard to your request to file, I'm going to absolutely, you can file a motion if you're asking for resentencing. That can be filed. And the people can respond to that. And frankly, at this point in time, I'm not even sure that I would be the judge who would be handling that at this point, because there is another circuit court judge in the county, separate and apart from because the last Judge Kingus is no longer on the bench, and so that Mr. Judge Jankowiak has an ability perhaps to hear this, unless of course he disqualifies.
I would add that Judge Jankowiak was Mr. Loew's first counsel. Okay, so perhaps it would remain with me then. And that's fine. I don't have a problem with that, but you can file a motion. I'm not going to make any prejudgment on that. You just go ahead and file your motion as you see fit. Thank you, Your Honor. Okay. Anything else?
Nothing further.
All right.